Henk, are we ready to run?
We're ready to go, Louise.
Okay, fine. Welcome to everybody. It's lovely having our first webinar this year. We've got people from our neighboring countries, Botswana, Zimbabwe, Namibia. We've got Vesta from Germany. I hope you are there, Vesta. Welcome with us. And Mr. Harry Rosen, I would like to welcome you. It is really a privilege having you on board. For those who don't know Harry, I just would like to, for those, especially in the neighboring countries maybe, he's the consultant CEO for the South African Optometric Association. He's also the ombudsman for the South African Association of Audiology and the ombudsman for the Ocularist Association of South Africa. Harry, we're looking forward to your talk. Over to you. Thank you very much. By the way, before you start, Harry, I just want to remind everybody, we'll do the questions afterwards. And please place your questions in the questions and answer department. Thank you.
Thank you so much, Louise. It's always a pleasure, to address an audience of healthcare professionals, and especially the invitation coming from Visiomed. The topic for this evening is simply entitled "A New Decade, a New Dawn." I don't think it's going to be a surprise for anybody, to state that the planet has undergone significant change in recent times from so many different perspectives. The pandemic itself has given rise to all sorts of consequences. It's just interesting that the year 2020 was planned to be an important and very special year for the year of optometry. The year 2020, as an example, the South African Optometric Association had very ambitious intentions, special events, to celebrate the value of optometric services. But needless to say, like everywhere else in the world, we got ambushed by a virus that is now well known as COVID-19. I think on the basis of that, for many people, when we consider ending a year, it's simply closing the door on one year and opening the door to the next. But I think for many of us, it was simply the concept of a revolving door where you just sort of spun from one to the other, and many challenges that existed in 2020 were simply transferred across to 2021. So this particular presentation, places a lot of, in fact, all the emphasis on ethical dimensions and ethical considerations. So some of which you'll note has not changed too much, but you'll note also that there have been some developments within the same sort of context. And yet there are other areas, such as the controversy surrounding vaccinations, which I am going to touch on a little bit, as I proceed through this presentation. So probably, at the risk of stating the obvious, the term new norms is very appropriate. The way that optometrists and other healthcare practitioners render their services is very, very significant, or the changes are very significant. The way that we dress and the way that we treat our patients. And that's not only restricted to optometry, of course, it's for all healthcare professions. There are many professions who have umbrellas in car parks before patients enter the actual reception area and so forth. So it's a whole new dimension, a whole new paradigm. And I intend to address some of the challenges that come with that sort of dimension. Look, from a societal point of view, one only has to read the newspapers that the human race has also undergone various shifts in terms of what's appropriate and what's not. In other words, our value systems have had to undergo all sorts of scrutiny. Probably, when we speak about a societal culture or corporate culture or a professional culture, the best definition is a group expression of values. What do we regard as relevant in our lives? What are our priorities? How do we treat each other? And it's with great regret, that we find ourselves spinning a bit. And that's a global phenomenon. South Africa has got its own set of peculiarities, some of which I will be addressing during the course of the presentation. But one only has to look at the United States of America just as an example to illustrate the point, how the culture of that organization, the nation, has changed dramatically with completely different ways of looking at various challenges. Well, bearing in mind, of course, that the whole concept or the topic ethics is a topic that's surrounded by the language of right and wrong, just and unjust, fair and unfair. And many arguments take place, and I refer again to the pandemic, of how various interventions were introduced. The vaccination, as I keep referring to, is just an example to illustrate the point. The distribution, how appropriate from one perspective versus another were the decisions taken by the authorities. So it remains very contentious by definition. And from early on in life, this type of terminology is really surrounded by ethical dilemma. Whether they're kids in nursery school or university students who protest, it's all to do with the language of right and wrong, what's fair and what's unfair, and that makes it difficult. There's so many factors that contribute to one's conclusion of what's appropriate or not. And I would like to suggest to all practitioners present, it's important to review the rules that govern you or regulate you at this point in time. So many laws have changed over time. What was absolutely illegal yesteryear have become very acceptable today. And I often give the example of the abortion laws. I'm not going to give my age away, but growing up, it was illegal. It was a criminal offense for even a doctor to perform an abortion. Yet a young girl today of 13 or 14 can have an abortion without parental consent. So if you consider this topic that we refer to affectionately as ethics, it is a branch of philosophy. It actually involves the study of conduct. Often people get confused between the word morality and ethics. The questions come up, why waste your time giving talks on ethics? There's no ethics, but the bottom line is ethics are the standards. That's what we aspire for. And it's the study of our morality, which is the implementation, it's the way that we do things. Just at the bottom of the slide, I don't think I've ever given a talk without highlighting this particular point. What's legally correct is not necessarily ethically correct. I think sometimes that's where some of the confusion comes in. And there are topics way outside the boundaries of professions such as optometry. So whether you're talking about the death sentence or euthanasia, these are really significant issues that are addressed on a daily basis. If there are 2 or 3 people waiting for a hospital bed, on what basis, do you allocate the bed? So those are some of the challenges, but I repeat, what's ethically correct is not necessarily legally correct, and the other way around. I'd like to move into the world of advertising. For many years, the issues surrounding advertising in healthcare in South Africa has been really top of the hit parade. I've often said that some of us who are intimately involved in healthcare in South Africa, our cell phones are the barometers, to determine what's, it's like a hit parade. What are the most commonly encountered challenges? So things have changed a little bit in recent times. The medical aids, as an example, I would suggest is on top of the tree, but closely followed by advertising-related matters And I am going to share some information with you that's almost hot off the press just to illustrate my point. There's also sometimes some confusion, the differences between touting and canvassing. So just to make a very basic point that those practitioners who are registered with the Health Professions Council are entitled to advertise. And that is underpinned by the principle of advising or informing members of the public in a responsible, factual manner without being misleading. But you also can't tout or canvass. And both those terms have qualifying definitions. Touting is simply enticing members of the public into your practices by using items or services that fall outside your scope. So in other words, non-optometrically related incentives. So if you had to say, for every eye exam, you get a free teddy bear, or you can win a trip to Russia, that will be touting. Canvassing is drawing attention to your qualities or your attributes. So simple examples would include highly skilled practitioners, 25 years experience, and so forth. Those really fall outside the boundaries of what's acceptable at this point in time. The other dimensions, which I'll just mention briefly, so simply you can't guarantee your services. You can't use fear to entice members of the public. If you don't come to our practice to have your eyes examined, you can go blind. So maybe some smile, at that sort of example, but please realize that these type of advertising campaigns do exist. Just to go back to the touting factor, even if you offer a free cup of coffee, come to our practice, have your eyes examined, and you can enjoy a cup of coffee with us. I don't know how to put this to you, but coffee falls outside your scope. So it would be touting. But what's become very contentious in recent times is the relationships with non-registered parties. And I think I take a little bit of a risk, but this is ethics. I'll do my best to stay within reasonable boundaries. But you'll find that there are loyalty programs that are taking place with organizations such as Clicks. I use that as an example because of a very, very recent development, which I'll share with you in a minute or two. And also the relationship with non-registered parties where there's an alliance, where there's a co-promotion, where, if you come to my practice, you'll get loyalty points and you can then enjoy those points at a store, which is not optometrically related. So there are two examples that I'd like to highlight that are both very, very topical and very contentious. I'm actually going to start with the bottom one first, the Hpcsa Ppin. And there's a very important lesson there that the ethical rule, the Hpcsa ethical rule that pertains to touting, canvassing, and so forth, is that if third-party advertisers on your behalf or in a situation where you benefit, the registered practitioners are held accountable. So I don't think it's any news for those of you who are in South Africa that last year there was an advertising campaign instituted by Ppin and Ppin appointed medical schemes where patients were receiving SMSs simply saying that, if you go to an in-network provider, you can get 50% or 47% better value. Practitioners turned to the Hpcsa for assistance, and the Hpcsa simply said, ladies and gentlemen of the profession of optometry, we have no jurisdiction over a Ppin or the medical aids, but we've got jurisdiction over you. So to cut it short, they charged 1,329 optometrists with unethical advertising. It went to the prelim inquiry, and the practitioners concerned, those who weren't in a position to provide a reasonable argument as to why they shouldn't. Now, they were all fined 10,000 Rand each. And for those who've refused or rejected the fine, in fact, some of us got correspondence from the lawyers today simply saying that there's been no further developments. It will go to a hearing. So I repeat, for those practitioners who've been fined, It will go to a hearing that will be arranged by the Hpcsa to establish whether the fines will be upheld or whether there will be a change. But with regard to the top one, on the 16th of this month, February, the Professional Board for Optometry and Dispensing Opticianry had charged the Chief Executive Officer of KFML with unethical advertising and unprofessional conduct. And the hearing took place in Port Elizabeth. So I'm only talking about a few days ago. And the charges were both related to the relationship between Specsavers and clicks. So please, I need to say there's no disrespect intended for any organization. You know, I'm simply sharing with you facts that have relevance and basically resulted in the Hpcsa charging certain parties. There were two charges, two counts. The one is that basically that if you consulted a particular practice, there were double points on the clicks card. And the second count was undesirable practice with click stores, bearing in mind that click stores, of course, are not part and parcel of the healthcare environment. And the results of the inquiry was that Mr. Daly was found guilty on both charges. And the penalty was a 6 month suspension from the register, but suspended for 2 years. So what that means is that if this type of situation arises again, in other words, if there's another complaint within the context of what I've tried to describe, then Brian Daly would be suspended from the register. And that, of course, is relevant for all practitioners. One's got to be so careful, you know, with the groups with whom you are associated. If they go outside the boundaries, if I may repeat myself, the Hpcsa has got no jurisdiction over them, but they've got jurisdiction over the practitioners, the registered practitioners. So one's got to be very careful. So this is a very, very recent development, and I'm sure all of those, all of you who are registered with Hpcsa, if you didn't know about it, will agree that it has significant relevance. There's no two ways about it, you know, that the verdict will be challenged and appealed. And that may give rise to another story. But for now, you know as much as I do. As I said, I'm taking a few risks this evening, sharing new information that's never been presented before. Well, one of the big challenges that the profession faces, but it's not just the profession, it's the members of the public, that the number of non-registered parties who are rendering professional services are increasing significantly. And I raise this particular example again as a matter of fact. So I'm not really, I'm not being libelous or casting aspersions. It's just simply based on fact. So Falco Milano is a group of stores, if I can call them that are pop-up. They refer to sometimes as pop-up stores. They're basically set up in the passages of shopping malls, owned by Israeli owners. They one of the biggest dispensing companies in Israel, and they've set up these Falco Milano stores in South Africa. The problem, unfortunately, is that many of the stores don't have registered practitioners who own them. So you'll find that stores such as Falco Milano are promoting dispensing of spectacles in particular, from single vision right through to multifocals. And there's been a whole host of reports. There's a group of very relevant people called the Inspectorate. The Inspectorate was set up by the Hpcsa, and the inspectors within that Inspectorate employed by the Hpcsa investigate cases of professional services rendered by non-registered persons. So some of you may recall that it wasn't such a long time ago in Vanderbijl Park, there was a supplier of lenses who was posing as a dispensing optician and was arrested based on criminal charges. So with regard to Falco Milano, there's been many complaints lodged. It went to court, the Weinberg Magistrates Court, and it was thrown out. So for those of you that were involved or had sent through complaints, usually when these cases are thrown out either by the Hpcsa, by the courts themselves, it's usually due to technical reasons, and no doubt the same took place here. So the inspectorate are pursuing they're pursuing the avenues available to them to ensure that all parties who are rendering or providing professional services who are not registered, and hopefully, in consultation and collaboration with the SOA now, to really try and put a stop to it. It's not just stores such as Falcon Milano. There are many cosmetic companies or shops. It's probably more accurate. There are the fancy dress companies that sell the cosmetic contact lenses. Some of them dip them in fluorescein. It still happens. So there is a war that's been declared to try and stop the illegal sale of optical devices, probably the best way to put it, across the board. Yeah. I don't think I have to say too much. The reference to essential services became a very topical, hot potato matter when the President, Cyril Ramaphosa, had declared the national disaster in March last year. It's credible as it may seem, it's a year ago. And it was just interesting that there was some confusion and who, in fact, are essential services. What about optometry? Do optometrists fall into the category of that particular definition? But when I say interesting, is that the government used the Department of Labor's definition of essential services. And the definition simply refers to services, the interruption of which will lead to detrimental consequences to the personal safety of the whole or part of the population. One of the reasons why there is a definition like that, and why the Department of Labor assumed responsibility for categorization of various sectors as essential services, is because if there's a strike and you're an essential service, that strike becomes illegal. But towards the latter part of last year, the Department of Labour and Employment, via the CCMA, put out it was really an invitation to all interested parties to comment. And those comments were related to whether, as an example, the private health sector should be regarded as an essential service. The thinking from many quarters was that, well, with the public sector in place, is it necessary to declare the private sector as a essential service? And where does optometry fit? So to cut an extremely long story very short, the South African Optometric Association did submit in strong support of having, firstly, the private sector being categorized as an essential service. I think it's fair to say that if you consider that definition, that within the private sector, if there is an interruption of those services, it will certainly have a detrimental impact on part or whole of the population. And then from an optometry point of view, from an optometry point of view, there's a whole host of factors which supports the motivation for the profession to be regarded and classified as an essential service. So the submission by the SOA was not simply, in fact, it had nothing to do with striking. It's because the government had used the Department of Labour definition when it came to restriction of movement, and it was felt that the government needs to acknowledge optometry as an essential service. But once again, without going through that list, there are many, many factors that support why optometry must be regarded as an essential service. So you'll see on the screen some of those examples. But what actually has happened is that despite the fact that the SOA had submitted on time, for some unknown reason, the submission wasn't considered. So what's happening now is that they have undertaken to address optometry on its own. So you'll soon see in the Government Gazette the motivation for optometry to be accepted and acknowledged as an essential service. So from the SOA's perspective, you will certainly keep everybody updated, but it's an important development, which I'm sure you all agree. I'm going to move on now to another very important field, telehealth and telemedicine. And sometimes the terminologies are used interchangeably, which technically is not correct. When the lockdown was the alert level 5 was introduced last year in March, the Hpcsa had put out a position statement, and where they had supported telehealth, and I'll come back to the definitions now, but only for established patients. And there was quite a lot of opposition to that position by some of the doctor groups and so forth. And then the Hpcsa revised their position to say that during the course of the pandemic, telehealth may be embraced by registered healthcare professionals for new patients and for established patients. The definition also was reviewed. So the broad term is telehealth, which really is simply an online consultation. So I'm going to go through this. Yeah. So telehealth is the umbrella term. It involves all forms of consultation which is done online. Telemedicine, I'll come back to that, my apologies. Telemedicine is really situations where there are 2 or more practitioners involved, and that has been happening for a long time. So if an optometrist sends a fundus photo to an ophthalmologist via the internet, then that would be telehealth. But if I consult my practitioner online, with or without other practitioners being involved, that would be a form of telehealth. So if I may repeat myself, Hpcsa's definition, telehealth is the broad umbrella term, and for the purpose of the presentation, the telemedicine is a category of telehealth. So just to summarize a bit, that established plus new patients can be seen by registered practitioners. The Hpcsa has stated that this can, especially with new patients, this can continue for the duration of the pandemic only. And they will then declare when the pandemic, has come to an end. Hopefully, it won't be too long, but nevertheless, and for those of you who do a claim for medical aids, the SOA did not have a code for telehealth at that stage, but there is a code that simply is described as consultation without examination, and 11041 was the code that was recommended for claiming purposes. I'm not going to go through every single sentence. It's just simply, just to qualify the term telemedicine, as I've described. If you look at the middle sentence between a healthcare practitioner in one location and a healthcare practitioner in another location. And it's simply to improve, facilitate, and enhance the services that are provided. Telehealth, this is a direct quote from the Hpcsa position statement. They're saying preferably be practiced in circumstances where there's already established practitioner-patient relationship. But they're also saying, well, if that relationship doesn't exist, at the risk of being absolutely obvious, they say, well, it must be done in the best clinical interest of patients. I think it's important that there are some factors regarding telehealth, especially for optometry, but for all practitioners, that from a recording point of view, it's important that the platform that's used for telehealth is accepted with the appropriate security in place, and both the practitioner and patient need to identify themselves. There has to be 100% informed consent from the patient, and also for the practitioners to assess the appropriateness of the consultation remotely. In other words, is it preferable to have this type of consultation vis-a-vis asking the patient to come into the practice? So, what's really important, again highlighting the importance of informed consent. For the professions of optometry and dispensing opticianry, there's still a position statement awaited from the professional board for optometry and dispensing opticianry. So if you have a look at some of the other professions like the biokineticists and the physiotherapists and so forth, you'll find that the professional boards have given guidance. So coming back to optometry in South Africa, which of course is relevant for the purpose of this presentation, what about examinations via the internet? Do we have the software programs in place? Is it appropriate? So at this point in time, those guidelines are still absent, and the SOA, as an example, has been lobbying heavily, asking the PBODO, the Professional Board for Optometry and Dispensing Opticianry, to please put out guidelines so that one can really understand and realize what the boundaries are and so forth. And I'm sure many of you will know that there are already sites that are up and running which state, by example, that purchase your spectacles online. We need a prescription not older than 1 year. But don't worry, if you don't have one, you will be able to undergo an eye examination for 450 Rand. So I am going to come back to online sale of optical devices. At this point in time, that approach falls outside the boundaries of what's permitted by the professional board. So I repeat, I will come back to that. And the only way to address it really is to lodge a complaint. But nevertheless, in the absence of those guidelines, it makes it very difficult. So moving on well, I spoke about a hit parade. I spoke about medical schemes, advertising, 1, 2, and number 3. Probably almost alongside advertising has been one of the big issues facing the professions of optometry and dispensing opticianry is the online sale of optical devices. I need to just state up front that many of you will know that there are guidelines in place, for example, for the sale and fitting of contact lenses. Those guidelines haven't been withdrawn. They are still very much relevant and practical. And if one goes through those guidelines, there's some important principles. And I repeat, they haven't been repealed. As an example, that if a practitioner is going to dispense contact lenses, he or she needs to have a really good knowledge of the patient's eye health. The guidelines clearly state that mail order is not permitted. So if those guidelines are in place, then how legitimate is it, at this time for practitioners to sell contact lenses? I'll come back to spectacles in a minute. So let me move on from that point of view. So on the 21st of August 2020, the Professional Board published in the Government Gazette draft regulations pertaining to optical devices across the board. And when I refer to optical devices, I'm referring to spectacles, single vision bifocals and multifocals. I'm referring to contact lenses, and I'm also referring to low vision devices. And all interested parties were given 3 months in which to submit a response. So submissions had to reach the Professional Board by the 21st of November 2020. So at this point in time, there's been no developments. but it's important to note what the draft regulations said. So online sale of anything, it usually takes the form of somebody sitting at home, going through some form of menu of options, placing an order, and within a day or two, there's delivery to the front door. But the regulations that were drafted for consideration by, members of the public and practitioners was that they were saying if you are going to sell online, if you're going to sell optical devices online, you need to have a physical practice. You can't just simply set up an online site. You needed to have a physical practice. That if you're going to sell online optical devices online, you need a prescription from the patient that's not older than 1 year. So if you stick to spectacles, members of the public would be able to select a frame, make available the prescription, but they would have to go to the practice for the dispensing. So it's a little bit different from the traditional way of, conducting oneself, shopping online. But those were the draft regulations. And, one has to just wait for the results of the submissions. An aspect of optometry that's been around for a very long time and remains an issue really relates to mobile practices. I think everybody will know that to operate a mobile practice, you have to apply to the Hpcsa for approval. The guidelines have changed quite dramatically. Initially, approval was only given to practitioners to operate their mobile practices in underserviced areas. But needless to say, there are competition-related matters there or issues. So one can apply for a mobile practice to operate in a built-up area, but there are a whole host of criteria that need to be met, in terms of standards of equipment, and, the type of mechanisms that are in place for referrals, for follow-through, and so forth. But to have a mobile practice, you have to have a home base. In other words, you have to have a physical practice, and your mobile practice would be regarded as a satellite to your home base. But importantly, your mobile practice can only operate within 50 kilometers, a 50-kilometer radius of your home base. And the reason for that is that if there is any subsequent complications or problems that may occur after the patients, for example, have received spectacles, then the thinking was that 50 kilometers was not unreasonable. But the reason why I thought it was not a bad idea to include it in this presentation is because for those of you that are involved in outreach programs, so even though it's for the benefit of the community, and you go outside your practice environment to render services to communities that are further than 50 kilometers, you're actually in contravention of these rules. So one's got to be cautious, because despite the altruistic approach that may be in place, it's important just to note what the guidelines are. So this is being challenged at the moment to say, look, we understand why there's a 50-kilometer radius, but one's got to be practical, because if it's going to prohibit or inhibit or dilute the value of providing services to communities in need, then one needs to relook at that. Just very quickly, the health inquiry was something that was instituted by the Competitions Commission in 2014. It took over 5 years to complete. And just to make a few points about the inquiry, so bearing in mind that this is a new decade, a new dawn, there were a whole host of findings with recommendations put forward by the by the panel. It was an independent panel that was set up by the Competitions Commission. So just very quickly, there were just 2 or 3 that I thought was important to share with you. The first is that they felt that the regulatory authorities who were responsible for regulating professions and medical schemes, as an example, within the private sector, really need to look at themselves for two reasons. The first is they felt that some of their rules were archaic and in fact were in contravention of competition law. And secondly, they felt that they were not really doing a good job of enforcing their own rules. So as a result of that, there's no two ways about it, from the information we have in our own engagement with, for example, the Hpcsa. Some of those rules are being reviewed in terms of the appropriateness moving forward. The rules, just as a matter of interest, that were highlighted by the panel, the Health Inquiry panel, were a little bit surprising. One would think they would be advertising related, where small and medium-sized businesses, which includes professional practices, should be able to advertise, but they focused on sharing of rooms and employment of practitioners. They felt that those rules were restrictive and need to be reviewed. The other thing that they put forward was the introduction of a new regulator. One of the big problems within healthcare today was based on the Competitions Commission's amendment to the rules in 1998, actually, but enforced about 2002, 2003, that professional associations were no longer able to make available guideline tariffs. Now, pricing-related discussions are in contravention of the competition laws. And in fact, price fixing and collusion is now regarded as a criminal offence. But in the absence of guideline tariffs, there's a void in certain areas. So this new regulator would be intimately involved in price negotiations. Obviously, for that regulator to become a reality, the competitions laws would have to be reviewed. This particular regulator would also be responsible for codes and also be responsible for practice numbers. At this point in time, the BHF is mandated by the Council for Medical Schemes to make available a practice number. But the proposal from the Health Inquiry panel was this regulator would assume those responsibilities. So I just felt it was important to share some of that. I'm going to move on now to vaccinations, COVID-19 vaccinations, surrounded by all sorts of controversies, sensitivities, but some of the points that are made here are really to be noted in my view, that of course the AstraZeneca vaccine, everybody knows, has been withdrawn in favor of the J&J vaccine. But of relevance is that the first 500,000 doses to be introduced to South Africa are introduced on the basis of a clinical trial. So there's a global clinical trial. 500,000 doses are made available to South Africa, to the government at no charge. And the reason for that is because it's part of a clinical trial. So some of the issues that have come up, you see on the screen. President Cyril Ramaphosa made it very clear, that it's not mandatory for South Africans to have the vaccine. But I'm going to share some of the legislation with you. You can see for yourself some of the controversy. What are the rights of employers? You'll see that there's an obligation of employers to ensure that there's a safe environment. But then there are the rights of the employees. The Constitution is very clear, that each South African has got the constitutional right to look after their bodies as they deem to be fit. There are also religious aspects. Well, what about refusal? If a staff member refuses to have a vaccine and then becomes, is tested positive, what are the consequences? So it's really just riddled with all sorts of issues. And simply to say at this point in time, then it's not mandatory. What the recommendation is that for those practitioners who are wanting their staff to have vaccines, it's really based on coercion and education. But just to share some of the legislation with you, the National Health Act, it just places the emphasis and the importance of nothing can be done without the consent of the user. So I'm going to go through these quite quickly. The Hpcsa Ethical Rule 27A says you've got to respect the patient's confidentiality, choices, and dignity. The National Act, the Section 71D, again, may not be violated without the user's informed consent. But this is very important, the second part, unless failure to treat, which includes the user, will result in serious risk to public health. So it's not impossible in the near future where the government can declare the vaccine to be mandatory, but at this point in time, it's not. Again, I've already mentioned it, the Occupational Health and Safety Act, where employers have an obligation to provide and maintain a safe working environment. So you'll see some of them are contradictory. And then lastly, but not least, the Constitution, which I've already spoken about, that everyone has a right to bodily and psychological integrity, which includes the right and not to be subjected to medical or scientific experiments without informed consent. So what can I tell you, in terms of the legislation, some of which appears to be contradictory at this point in time, it's not mandatory. And employers, the best they can do in the views expressed by the experts was, you need to encourage, if the employers want to introduce some kind of policy, they won't be able to impose that policy, on their employees. But what's become quite controversial is that government, because they've only got 500,000 doses available as a starting point, have appeared to give preference to in-hospital providers versus out-of-hospital providers. And there are a number of provider groups that have not taken kindly to this and are in the process of establishing lobby groups. They believe that the 500,000 doses should be distributed equitably, that there are certain situations where providers who are not in hospitals are at great risk, whether they're in a hospital environment or not. So the jury is still out on this. But just to move on, the government, however, has said to professional associations, actually, to prepare a categorization as per what you see on the screen. So that's all based on the categories of the greatest risk to the COVID-19 infection. So as an example, category 1, those conducting aerosol generating procedures with examples, those in direct contact with known or suspected COVID-19, those in contact with patients who are not known or suspected to have COVID-19, and then lastly but not leastly, those who are not in contact with patients. So that really is just a very, the category really, if you remember, there are 3 phases for distribution of the vaccine. And phase 1 incorporated healthcare workers. So if I may repeat myself, the request was for professions to organize themselves in such a way that they would be classified as per what you see on the screen. So just to conclude, Louise, there are just 2 aspects that I thought was really important to raise here. The first, of course, is on everybody's lips. In fact, it's been on everybody's lips for a very long time, and that's the POPI Act, the Protection of Personal Information Act. People have been threatening each other with this particular act, long before it became. Well, when I say enforceable, I'll come back to that. Actually, it was brought into law for the purposes of what it was meant in July last year, 2020, and everybody was given 1 year to get their house in order. So at this point in time, private sector, public sector entities, and so forth have to ensure that they are compliant with the Personal Protection Act, POPI, as from the 1st of July 2021. So if I may say through yourself, Louise, I mean, there are guidelines. There's been so many documents written, but for those who want a list of guidelines, they can obtain it from the South African Optometric Association via my address or via yourself. But it's really, really important because, if there are violations, the consequences are not to be taken lightly. just to highlight, if you look at the definition of personal information, it's very, very broad. The lady on that ID card looks vaguely familiar, but nevertheless, it's very extensive, ranging from the name of a person right through to religious affiliation, medical history, and so forth. All of that is protected by the Protection of Personal Information Act. And it's worth reading the act. It's not a complicated act. It's not a very long act, but it's really important to come to terms with that particular piece of legislation. And it opens up all sorts of doors. Now, as an example, if somebody phones me for a reference for an ex-employee, what are my rights? What are my restrictions? So without going into detail, it's an important piece of information. Now, that's a little bit faint, but please bear in mind that to be safe, as a starting point, when you are going to reveal any information, especially from a professional practice point of view, you need to get the patient's consent before you release that information. I'll come back to some of the parameters. It's also important, if you have third-party arrangements, as an example, for those of you that have a relationship with a marketing company or with an IT company that have access to your information, it's important to have an agreement in place with each of those third-party players. For you as practitioners, you're going to be regarded as a responsible party. In other words, patients will come to your practice, they will make available the information, and I repeat, you will be the responsible party. And if you are going to share my information with third parties, you need to have some form of contract in place to safeguard yourself. And that contract, as an example, needs to specify what each third party is going to do to ensure the safety of that information. And then information security is really a no-brainer, as they say in the classics. As an example, if you have staff members who have access to your database, it's important for each staff member to have his or own access code. Not to have one code that's shared amongst everybody, that the database is secure. If you have files in a filing cabinet, not to have it next to an open window or a door where you have easy access. That's just a point too. And then lastly, but not least, it's another piece of legislation that's been around for a very, very long time with many extensions, and that's the Promotion of Access to Information Act. So some people get confused between the Act, POPI, and PIA. So POPI is to protect your personal information. The Promotion of Access to Information Act, I think an example I can give you, that if you apply for a home subsidy and your application is turned down based on information that the party has at their disposal, you are entitled to that information. And the Promotion for Access to Information Act basically gives you the license to apply for that information. So when I say there have been many extensions, each entity in the private sector and public sector had to make available a manual. A manual always sounds bigger than it is. It's simply a document which highlights the type of information you have within your practices, and also the procedure for parties who are wishing to have access to information, that procedure that needs to be followed for you to consider. It's not just an automatic thing because there's an act in place. The manual was supposed to have been compulsory in, if I remember, to the end of 2015, December 2015. Then they introduced an exemption for practices or businesses, and the parameters were as follows. It's for practices who had less than 50 employees or had an annual turnover less than 5 million rand. So that exemption carries through to the end of December 2020. What they've actually done now, they've extended that exemption to the end of April 2021. So there hasn't been any other publications or indications of whether they're going to extend that exemption again. But if it is not, then it becomes a legal obligation for every single practice annual And once again, Louise, if you don't mind me saying so, if anybody wants a copy of a template of the manual, they're welcome to, they can contact myself, either through you or directly, and I will make available that template.
You're most welcome, Harry.
Okay. So, ladies and
Harry,
gentlemen,
are you finished? We want you to keep on talking.
thank you, Louise. I've
Thank
actually.
you. Thank you very much. We've got a few questions, Harry.
Sure.
Would you like to go to the Q&As? And then you can also just read the questions with me. This first one comes from audience, Maluleke. Why is it wrong for one to say they have 20 years experience? It is factual that such experience has been gained, and if you were to think about it legally speaking, that is why there are different grades, candidate attorneys, directors, counsel, and senior counsel. That refers to their experience. Although I can concede that being of 20 years experience doesn't mean the best, experience shouldn't be inflammatory.
All right, that's a great question, audience. Again, when one looks at the ethical rules, one looks at the letter of the rules and the spirit of the rules. And in essence, from both points of view, the intent is not to show superiority in any way, in relation to your colleagues. You'll appreciate it at this point in time. So if you look at the definition of canvassing, it's basically you can advertise, but you aren't allowed to refer to your attributes or qualities. So by announcing to the world that you have 20 years one would then regard that within the category of showing your attributes or your qualities. You have a particular advantage, and that's why such statements really aren't accepted at this point in time. Ideally, whether one agrees or not, and I repeat, at this point in time, probably the safest way of advertising, I'm repeating myself, within the current boundaries. I'm an optometrist. I provide the following services. These are my fees. These are my consultation hours. These are my contact numbers, along those lines. So it's purely factual and responsible. Once you start referring to yourself with attributes, that basically then falls foul of the definitions of the ethical rules.
Thank you. By the way, Leonie, I see you've asked a question on the chat. We'll get to you now. Nanda Glover, regarding Falco Milano, what is the stance of the landlords where these pop-up shops are located?
That's a tough question in many ways. Many of the landlords have been contacted, but the problem, of course, is organizations like Falco Milano have basically claimed to be legitimate. And the landlords find themselves in the middle of a dispute regarding legislation they don't necessarily understand. So when you say what is the stance, there have been one or two landlords that have shown to be sympathetic, but you'll find that despite that, many of the shopping malls where there have been issues raised, this particular company and others have continued to thrive. So the only way to stop it really is via the police and the inspectorate. I think the other complicating factor is that the police and the courts don't always understand not only the rationale behind the legislation, but the legislation itself. If you consider that when you go into a police station and they're dealing with some really horrible crimes, and you say these guys are dispensing spectacles and they don't have an optometrist, they don't really regard, they don't understand the seriousness. So I think there needs to be a campaign, to really, an awareness campaign at all levels, because I don't have to tell anybody present, there are very severe potential consequences for lay people to be providing professional services. But Nanda, I'm sorry, I can't do better than that, except, if there is a campaign that landlords have to be made aware. All I can say, I personally appeared in a court about a year ago, which was a little bit different to this case, where the landlords were involved, and the judge didn't really put much responsibility on the shoulders of the landlord at that stage.
Thank you. Will optometrists be vaccinated in the first round of COVID-19 vaccines?
Yeah. So the best I can do really is based on information available. I just, before the presentation this evening, I did put feelers out to establish whether optometrists have already been vaccinated. The answer is yes, there are optometrists that have already been vaccinated. But the intent is for optometrists to form part of phase 1. The challenge, as I said early on, is that there's a limitation of stock. And I tried to allude to that early on, in terms of the government decision to focus more on the hospital practitioners rather than out of hospital. But the actual thinking was that optometrists would form part and parcel of phase 1. Bearing in mind, that very close proximity to patients and are at risk.
Thank you. Zahira Baruch has asked, we recently came across a letter being sent out at schools stating that speech therapists would be conducting eye screenings for learners of the school. Is this allowed and within the scope of practice?
Yes. Yes, I think that letter was made available to me and others quite recently. So I just want to just sort of separate two different professions. So from a speech therapist point of view, technically that falls outside their scope. And in fact, if you have a look at the guidelines regarding school screening, it's clear, that the appropriate practitioners, eye care practitioners, should be responsible for the screening. There's only one other profession, which is a bit of a surprise for most, if I have to say, including myself, and that is the occupational therapists. Part of their scope is visual therapy. And although in many cases when one has investigated that, they refer mostly to optometrists when visual therapy is needed. It's part of their scope. And there was another letter that was out quite recently where an occupational therapist was speaking about screening. So the question, directly is that from a speech therapist point of view, I would say, it's not part of their scope at this point in time. For occupational therapists, visual therapy is part of their scope. Thank you, Louise.
Thank you. Leonie Dubin, what happens when our staff refuse to be vaccinated, but the patients insist that they will only attend if they are safe and everybody is vaccinated? Another issue is that of a GP friend who has just been vaccinated, had to be in a room with more than 70 other healthcare workers to get their vaccination, potentially making each vaccination event a potential super spreader. Scary stuff.
Yeah, no, thank you, Leonie. As usual, your questions are really well thought through and very, very relevant. So you'll appreciate, it's easy for me to sit here in a meeting such as this and spout off all sorts of recommendations. But on this particular issue, I'm talking about forcing staff members. We did receive legal advice. And at this point in time, there's nothing to force anybody to have the vaccine. It's their right, their constitutional right at this point in time. So that's a tough call. The only thing one can do, I repeat, underline, at this point in time, is to try, if that's the position that the owner or the practice owner or the employer wants to take or introduce a policy, is to educate and encourage the vaccinations. But to force it is not supported legally. There's no two ways about it. The courts will see various cases, where some of these principles will be challenged. But at this point in time, only one can't force the staff to have vaccinations. And it's a tough one, if patients insist. Unfortunately, the staff members have got constitutional rights. And I'm repeating myself at this point in time. Yeah, your other question, in terms of having a room full of practitioners, whoever, what can I say? I'm no expert really on the infection itself, but one would think that interventions are put in place to ensure that all parties are protected at all times. And I would say that, if that is a true story, one needs to take it up with the authorities. One can't go ahead and contradict the very, very basic principles, because even if you have vaccinations in all over the world, it's never ever to replace the continued wearing of masks, the continued use of sanitizers and hand hygiene, the continued social distancing. All those still remain in place. So the vaccination is no excuse, in my view, to move away from that. In fact, on the contrary. So I would say if that in fact was true, then the authorities should be made aware of it, because it is a blatant contradiction of what's supposed to happen.
Right. What is the current status regarding the Hpcsa and Ppin providers?
Okay. So we received a letter today, funny enough, from the lawyers representing about 400 or 500 practitioners who were charged. And with the greatest of regret, Louise, there's been no development. I did try and allude to that early on, to simply speak about the fines that were imposed. And for those who have rejected the fines, will go to a hearing. There were two waves of charges. So there was one group that were charged by the Hpcsa. It went to a prelim committee, and then there was a second group. So in total, there was 1,329. It appears that 800 of those, I'm just rounding it off, had rejected the fine. So the COVID-19 pandemic appeared to have some impact, which has delayed the process. And then what happened during the course of 2020 was that there's been a change of the guard. In other words, the professional boards changed, and each professional board has got what they call a preliminary committee, who basically then assesses the charges, and it was the prelim committee that fined all these practitioners. So the professional boards have changed, the prelim committees have changed, and that also had a huge impact on, and a delay. So at this point in time, there's been no developments whatsoever, and the best that, from a personal point of view, and the SOA can do, is keep the profession updated. But unfortunately, that's the best I can do for now.
Thank you, Harry. Wendy Hested, is a domiciliary visit to a patient who is unable to travel to a practice due to health or mobility reasons also restricted to the 50-kilometer rule, and what other rules would apply?
Yeah, great question. Again, you've got the spirit in the letter. So in technical terms, any service that's rendered out of the practice environment is regarded as a mobile practice. It's as simple as that. And what one would expect under those circumstances for the practitioners concerned, to apply for approval. So I can only answer that from a technical point of view. So in my view, it would be a contravention, despite, as I tried to say earlier, even for outreach projects and community service programs, that if you render services outside your practice environment, that is a form of mobile.
Right, there are two questions from the same person. Why certain Ppin providers have been fined by the Hpcsa and not others? The second question, what is the latest dispute between Hpcsa and Brown-Doley?
Okay, so the first question is a difficult one to answer, because the information we have is that Hpcsa simply got a list of practitioners from the website and the database actually that was shared via the SMS. I'll come back to that now. So they just took the list that they believe to be PPN network providers and charged them. It just goes back to what I tried to indicate a little bit early on, that the touting via, or let's just call it the unethical advertising, allegedly, as per Hpcsa, was sent to patients who visited or consulted non-PPN providers. The SMS basically said, as I said early on, you can get better value at an in-network provider, and there was a whole list, where you click to see who those in-network providers were. So if I may repeat myself, the Hpcsa got their lists from that type of database. Even within that database, there were people there that had not been practicing for a long time or had resigned from PPN about 3 years before and so forth. So it wasn't a perfect strategy, but they just went for the list that they had. So other than that, I can't comment further. But with regard to the dispute, it was to do with the clicks campaign, and that's what I showed early on, that Brian Daly was held. In fact, what happened is, I'm not going to mention names of the practitioners, but I'm simply going to give the facts as we have them. So it was a particular practitioner in Cape Town who lodged a complaint against Brian Daly specifically for the clicks campaign, because as you probably know, the clicks had sent out SMSs to their clientele promoting Specsavers. So based on the complaint lodged by this particular practitioner, the Hpcsa then charged Brian Daly. Brian Daly actually, the complaint was against him personally. So the Hpcsa then had instituted those 2 counts against him, and then on the 16th of February, the hearing took place. It went to a prelim committee first, and then the conclusion was it needed to go to a hearing which took place on the 16th. So I think the word dispute is probably not accurate. It was simply Hpcsa acting based on a complaint lodged against Brian because of the association between clicks and Specsavers.
Good. Ignacia asking for a friend. Can somebody practice from their home or their house? What are the conditions?
Oh, there's no real restriction. One thing about optometry, the business and practice models are so diverse. And that's why even when there have been practice cost studies done, it's been difficult because there are differences. There are practices in shopping malls, there are practices in medical centers, there are practices in homes. So the answer to that question is yes, of course you may practice from your home, but there are standards of practice. The Hpcsa got guidelines in terms of the equipment, the environment in which you conduct your examination and so forth. So if those criteria are adhered to, then there's nothing really stopping any practitioner from practicing from home.
Right, coming back to the vaccination, Nicole just mentioned that surely you may not disclose whether someone is vaccinated or not. So patients have no right to know whether your staff are vaccinated.
Yeah, that's another difficult one. Everything is supposed to be with informed consent. And I think those practices, all practices need to review their policies today. But it's become such a contentious topic. But I do tend to agree with that principle that the vaccination of those parties who have been vaccinated needs to be with informed consent. There are forms that are available, and I think to be safe, from all points of view, is to have people just consent accordingly.
Right, that concludes all the questions, and I think it concludes the evening. Thank you for everybody attending right up to the last moment. Thank you for your time, the preparation. I don't want to know how much time it took you to prepare this. And I know that Bleda is also the artistic person when it comes to the compilation of all these funny little pictures in your interesting slides. I would like to say thank you to Henk and Caitlin. They're our technical team. They are our backup. They're the backbone of this webinar, and we can't go without you. I just want to ask you, be patient regarding this certificates. I have not received any accreditation and numbers. And yes, my daughter is visiting from London and she's here for quite some time. So we're buying the time out with them. So at this moment, you will have to sit in the back seat. I'm sorry about that. But as soon as I've got the accreditation numbers, I will post your certificates. Thank you very much. Good night to everybody. Tuck in well and enjoy your warm beds in this cool night from Johannesburg. Thank you. Bye-bye, Harry.
Thank you so much, Louise, and thank you to everybody for your attendance. Have a good night.
Thank you. Harry, you can leave if you want to, okay?
Okay.
Everybody's starting to leave now. Thank you very much.
Thank you so much. The trick is how to leave. So.
In your right-hand corner,